Oh, okay, let's go.
Anyway, the rule is the commission shall constitute a quorum at any meeting. So we have 5 current members, so 3 of you is a quorum.
Okay. Let's get started.
That's good.
Crank through it then. All right, this May 1st meeting is called to order. I guess I'll do the roll call since Rudy isn't here. Chairman Patterson is absent, as well as Anthony Perez also being absent, whereas Mr. Garcia, Mr. Lukes, and myself are here. The 2 vacancies are still vacant, as far as I'm aware, so according to Mr. James, we do have a legal quorum because the total number of members is 5, and we have 3 people here, so we are starting like that. Mr. Perea, we just started.
Okay.
So we went ahead and did roll call ourselves. Okay.
All right, and my apologies, Chairman, but I just came in from Albuquerque from a zoning officials meeting, and then I'm going to drive back after this. So please accept my sincere apologies for being a little late.
Apology accepted.
We actually feel sorry for you.
Yeah. Except you're using taxpayer money to use our gas to get down there. And wear and tear and depreciation on the vehicle.
So if you'll excuse me, I'll just put up your name plates here, and just so the public knows who you are. And then again, pardon my lateness, but couldn't be helped. Okay, so here we go.
Mr. Rodriguez? All right, guess we'll stand for the Pledge of Allegiance. Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we're moving on to the agenda. Item number 3. Does anybody have any changes to the agenda? Having heard none, do we have a motion?
So move.
We have a second?
Second.
You're gonna have to tag team each other. Okay.
Aye.
Okay, all in favor? Okay.
Aye.
All right, let's move on to the meeting minutes from April 3rd. Do we have any changes or comments?
I'm good with it.
Same here. I'll make a motion to approve the minutes as presented.
We have a second?
Second?
All in favor?
Aye.
Okay. Is anybody signed up to speak for the Citizens Forum?
I would like to speak to it. I didn't
Okay,
notice the sign up.
yeah, let me go ahead and get that for you, Mr. Murphy.
I'm gonna be talking about the sign code, if you wanna wait till then, you can speak then or speak now.
Okay, so we're gonna go ahead and sign it for the agenda.
Well, I think my comment would be that we're not trying to pass anything on the sign code. It's merely a discussion. So I think you should just talk during the Citizens Forum, and once it comes to a motion at some point, if in fact that happens, you would speak on that at that time.
Okay, so you're gonna wait? I'll
No,
speak-
go ahead.
I'll speak later.
No, now.
Now, so.
Okay, thank you, Mr. Murphy.
So I have a
Swear in.
presentation that goes,
Oh, you don't
it'll
have to
probably
swear
go
in.
for 12 to 15 minutes, but I kind of go through the sign code, and parts that I think are relevant. But I'll go quickly. That's okay?
Sure.
All right, I have a couple introductory remarks in no particular order, just because I apologize, I didn't have time to make a coherent introductory presentation, so I just have 4 or 5 sentences or 2 that I want to read. And then I'll get to the analysis of the sign code as I see it. I think it's the duty of government to promote free speech and expression of ideas and do everything possible that's reasonable to do that. And I think the sign code does not recognize that, in fact, goes to great pains to deny the rights of free speech. If the only, and another out of order subject, if the only purpose of a roadway was to promote safety, automobiles would be banned, or at least not have 40 mile per hour speed limits, which is what we actually have in Taos from like the Witten Inn all the way out to the bypass. The speed limit is 40 miles an hour, which is, you know, a totally irresponsible and speed limit to have, and yet no one complains about it. So when the complaints come in about my signs or other people's signs causing a traffic hazard, that rings hollow when you compare it with the speed limits through this town. The amount of businesses, in and out traffic, middle lane, none of that warrants a speed limit anywhere near that. 30 miles an hour would probably be much more reasonable than 40. The current sign code, when properly read and construed by code enforcement, Taos Police, and the municipal court, allows for reasonable signage related to picketing and protest. The draft before us tonight virtually eliminates public protest, all the worse when the local media is corrupt. In other words, there isn't really a whole lot of free speech that can be expressed in Taos in the traditional ways, either through the media or street protest. The New Mexico Department of Transportation does not own me nor my rights of free expression. Amos Khan, protected by the corrupt Taos politicians' administration, does not own me or my signs. The New Mexico Department of Transportation should not be included in this sign code or referred to in the sign code. All right, do each of you have a draft copy of the sign code? Okay, yeah?
Yes, we do.
All right, Mr. Dennis, you have it?
Yes.
Okay.
Do you have a copy of it?
Do I have a copy? I have a copy that I received from Brian James's office, like about on Thursday. That's what I'm working from. So when I refer to page numbers, hopefully we'll pretty much be on the same thing, but I'll use numbers.
Mr. Northrup,
Yes.
just for purposes of, I don't know, efficiency, do you mind when you're making reference to your comments about the sign code and what you have difficulty with, can you make a reference to the section within the draft that we're looking at?
Yes, I'll try to do that, certainly. Okay, and keep in mind that there really isn't a whole lot of numbering going on but there is some, so I think we'll be able to be on the same section at all times. But if you get confused, stop and I'll work with you. The first 4 pages of this draft are mostly drivel, nonsense, and statements based on unsubstantiated speculation, suppositions, and prejudices. Even the town's master plan is invoked, a document to my knowledge that has never been adopted. So let's go to the bottom of page 5, and let's see if we're all looking at the same thing. It's on my copy it says 1508 XXX fees and penalties applicable to permanent signs. Is that what you're saying? Okay,
Yes.
good. This raises the fee on signs of less than 23 square feet, as the minimum cost will now be $47 per sign, as opposed to $2 per square foot, or $47. Now it's all $47. On page 7, about 2/3 of the way down on my copy, general design and regulation of all signs. We have under A, all permanent signs shall relate to the purpose of specific business entity displaying, same, shall be consistent upon any premise and basic design, style, color, and manufacture. This is a very demanding standard to reach, and also it's just not Taos. Taos doesn't work on, this is not Scottsdale, it's Taos. We don't work on that kind of rules and regulation relating to business. It's just not the way business is done in Taos. It's expecting way more than is necessary. Section B uses the expression visual hazard, and there's no definition here or anywhere else in the code that I can find of what a visual hazard is. And you can't use expressions like this. It leaves way too much discretion to enforcement. It's got to be defined in some way. Section E. The size of temporary sign does not count towards 60 square foot maximum sign area and permanent signs. And it's pretty difficult when when you've gotten to your 60 square feet or whatever it is you're allowed to then try to incorporate your temporary sign. You know, generally in the old code, you might be up to the maximum in the signage that you're allowed, and then when you had a temporary sign, a banner, or whatever for an allotted period of time, it was not prohibited if you'd already reached the maximum amount of signage that you were allowed. Section F. I don't understand the reason for having a permanent freestanding sign only allowed to be 40 square feet. That's not very much. That's only like 6 feet by 7 feet, and that's pretty small. The current sign code doesn't have any sort of restrictions like that, and I don't know what the thinking is. Maybe there's some good reasons for it. I just don't realize them. In section G, I think where the word minimum used, the word maximum was probably intended, so that's more typographical error than anything. Okay, page 8. Number and types of signs permitted, so that's just near the beginning of page 8. It said that you can only have, section 3, number 3 there, says you can only have no more than 2 temporary signs permit per year, and they have to be 30 days in between the one use and the next, but it doesn't say how long you can have that temporary sign for. Is it 15 days, 30 days, 90 days? Doesn't have any definition there. Further on down, right, like four or five lines up from the bottom of the page, it has a little heading called banner, and I don't understand why the banner must be attached to a building. If you're going to have one of those temporary banners, I would think there's other ways of displaying it, particularly if your building is not in a very visible place to begin with. You want to get a banner out near the street, not against your building, like, let's say where the old Bean coffee shop used to be on the south side. You know, a banner on that building is a very marginal value. You know, it's just too far from the roadway. Page 9. It says that, for instance, there's 3 definitions of multiple tenant centers: 2 to 5 tenants, 6 to 9 tenants, or 10 tenants or more. And for instance, if there's 10 tenants or more, in total they're restricted to 100 feet of square signage. That's ridiculous. In a shopping center like Albertsons, where Albertsons is, I venture to say there'd be 12, 13 businesses in there, which means each business would be restricted to a sign of about 8 square feet. My picketing sign, just as a way of point of reference, are 6 square feet or close to 6 square feet. So you put 8 square foot on a building or 10 square feet on a building, that's not going to really do any business a whole lot of good. Okay, page 10, top of page 10. A-frame signs are prohibited on the Taos Plaza. I don't know the reason for that. The sidewalks are plenty wide enough. Generally, what the A-frame signs you see on the plaza are along the sidewalks there. Those sidewalks are quite wide, and you can kind of sort of more or less hide an A-frame sign behind one of the posts along the way there, and they're not really a hazard to people walking. Even if they do stick out into the sidewalk beyond the post, it doesn't really endanger anyone, and I think they're of great value to shops along the plaza, drawing attention to what it is that they're selling. Exempt signs. I kind of alluded to this before in my opening remarks. In the introduction to conditionally exempt signs, right at the end of that paragraph, we see the words defined sign, define design criteria. And, you know, who's gonna be putting forth the definition of design criteria? And, you know, these are all very difficult definitions and restrictions, and I don't know why we want to even think about doing such things. Okay. Under that section, we have a section N, which is picketing signs, conditionally exempt signs, so it might seem like, well, that's pretty good, picketing signs are exempt, but we'll see in other parts in this draft of the code that really picketing is extremely restricted. It's not really exempt at all. You're pretty much confined to having just one handheld sign, period, if you're picketing or protesting. And again, on this, on that same page, pretty much the last line, under exempt signs, in other words, for the exempt signs, it says picketing and election signs are fully exempt, but yet there's no definition as to why they would be fully exempt. In the definitions, at the end of this draft, it clearly states that picketing is kept to one sign, handheld, period. So I don't know why it's listed under exempt signs.
Just to interrupt real quick, how many more do you think you have?
How much further I have to go? Unfortunately, probably another 10 minutes.
Do you think what you could do is kind of highlight some of the stuff and make some notes? and
Okay.
Then perhaps you could send it to the commission? Like maybe scan it in and send us an email so we can review it and look at your comments for the next meeting? What do you think about that?
Well, I could do that, but I could also set this aside and quickly talk about things without referring to them directly. I can, I'll do whatever you'd like, but, I mean, if you're gonna be discussing the sign code tonight, I think this will wind up being a substantial part of the discussion, what we do right here. And when I get done, I'm guessing that there won't be a whole lot more discussion. Am I right or wrong?
I think it would be more effective, at least from my standpoint, is what the chairman suggested, because then I can actually deal with all of your points and have time to think about it, and for the time when we're actually gonna be voting on this.
Okay, well, let me read some things then. So give me, if you'll be so kind, let's say give me 4 minutes.
Okay.
And I'll just read some things and try to edit it as I go along. The code refers to the right-of-way as related to the right-of-way definitions in the state law, New Mexico Department of Transportation. And we need to, and I talked about this at our last meeting here, that we need to have our own right-of-way laws and not rely on state laws. We should write our own zoning laws as the community sees fit. If the state begins pushing our citizens around, maybe we should fight the state on behalf of our own citizens and not be bound by their right-of-way laws. I've yet to see a state map that begins to clearly define the width of the state right-of-way south of the Kachina Lodge stretching to Ranchos or anywhere along Kit Carson Road. In other words, this makes reference, the town has more or less ceded the definition of the right-of-way, which is really going to be the heart and soul of this document. They've ceded it to the state, New Mexico Department of Transportation right-of-way laws, or whatever you would call them, ordinances. And first off, we don't even know what they are. And we can't go anywhere with this document as far as I'm concerned until we see a clear definition of what the right-of-way is, and that each business in the town understands or could come in and look and see where can I put my signs and where can't I, based on whatever is in the final draft of this document.
Well, just from my knowledge, each business owner, if they're property owners, they'll know where the right-of-way is because it will show in their survey.
Well, that's true,
It is.
and that's New Mexico Department.
And that's the Department of Highway, and it's not part of the zoning or land use code. There's nothing to do with that, to my knowledge, and I can be corrected if I'm wrong. the town has nothing,
I think we should take it up in the discussion. during-
All right, well, I will go, where would I go to find those documents? What,
surveys from any surveyor.
any survey, would the county have that?
In the county records, you'll find.
So I'll find it in the county records? Okay, well, I'll look, okay. All right, so, you know, I'm obviously very concerned about the health of businesses in town, and I'm very concerned about my free speech rights and other people's free speech rights. So I'll wrap it up there.
Thank you,
Thank
Mr. Northrup. Mr. Perez, is anybody else signed up to speak?
No, Mr. Chairman, nobody else has decided to speak on this issue.
Does anybody in the audience wish to speak? Okay. All right, let's move on. Matters from staff. Is this you, Mr. Perea?
Yes, Mr. Chairman. Under matters from staff, under item 6A, what you have before you is a copy of the, some parts of the, well, there's only actually one part that's been updated by staff, and that is under section 5A, subsection 4, where you see it highlighted as Citizens Forum. Per the direction of the town clerk, I added that in there because our previous agendas did not have a Citizens Forum in them, so at the direction of the town clerk, that's the only thing staff has added. And I know over the past couple of meetings, Commissioner Lukes has expressed concerns about the way the commission elects chairman and vice chairman. So I would turn it over to the commission to discuss that, and we can possibly update these bylaws based on your input tonight and with the input of the town attorney to see if we're.
I'd like to direct this a little bit. Before we
Sure.
get into the election stuff, do we have any other general comments about the bylaws generally before we get into the election?
Just one question. So
Sure.
this drafted bylaws is from the bylaws that we approved, except for that one change? Is that what you're
Yes,
stating?
that's correct, yeah. These were approved at the beginning of, at your first meeting for the 2013 calendar year.
I know what your next question's gonna be. Go ahead, present it.
Well, within this document, under quorum, section 3, it indicates that it requires to have 4 members to have a quorum.
Yes,
We don't have 4 members.
no, that's correct, Commissioner Garcia. Right now, because the Planning and Zoning Commission only has 5 members, you guys are a quorum because there is a majority at this point. You know, when this was written, you know, where you point out that section for 4 members, that's for a full 7-member commission, you know, standing commission. But at this point, you know, officially, there's only 5 members on the commission. So right now, there is a quorum for this meeting, and I did discuss this with the town attorney before this meeting, if this constituted a quorum, and he indicated that it did, because right now, officially, there's only 5 members on the commission. So this is a majority because you 3 are here, so.
Wow,
Maybe we have to have the provision,
I think it should be edited for sure.
Yeah.
Okay,
I
so,
think a suggested edit would be not shall be 4 members, it shall be a majority, is what it should
majority,
say.
okay.
or 4
All right,
members,
that-
unless the commission is.
Well,
And
I
not fully.
think where I'm confused, and of course, I'm not an attorney, but, you know, the panel, the commission is 7 members.
Yes,
And I know that there's 2 vacancies at this time,
that's correct.
but in reading what I've read is a quorum is 4 out of those 7, even though there's 2 vacancies. And I think the public could see it differently, and I just want to make sure that we're conducting business accordingly to where the public understands that this is a majority, because there's 2 members that have not been filled. But
Okay.
I have an issue, and I think the language needs to change, or something needs to be spelled out, that we do understand that there's only 5 members. Some language that indicates if there's only 6 members, because we haven't filled 1 position. I understand that,
Yeah.
but it needs to be spelled out someplace.
Yeah, that's a good point, Commissioner Garcia. Now that you were speaking about this, I think maybe some suggested language would be a quorum would constitute more than 50% of the planning and zoning commissioners being present.
Standing.
Yeah, standing commissioners, would that language work for you
Well,
guys?
yeah, something like that, just,
You know, in other words, put it as a percentage rather than just as a specific number, because at this point, you know, unfortunately, we don't have a full commission at this time. Would that,
yeah, I just
Would
think, looking at the
be okay?
resolution, it's, the way it's worded, under
Okay.
quorum, I think it's just not clear enough, in my opinion.
I agree.
Mr.
okay,
Chairman,
then,
if I might, I
Mr.
would
James.
strongly suggest that those things that are covered in the ordinance are in the ordinance, and it doesn't matter what your bylaws say. You can't be adopting bylaws that are in conflict with the code.
So why even have bylaws?
You have all the bylaws you want that aren't covered in the code, you just can't make your bylaws that are in conflict with the code.
So, is there something in here that says is this referring to the land use development code? Is that what you're referring to?
Yes,
Okay. And there actually is a section in the bylaws that says that the land use development code trumps the bylaws if there is a conflict, correct?
I don't know if there's that section, but I mean, as a matter of law, that's true.
I think it actually says it.
And how is it worded? Under the,
There it is. I put myself on the spot. It's section 6M. Says to the extent that anything in these bylaws is contradicted by the LUDC, the provisions of the LUDC shall govern.
You know, the code says the majority of the members of the commission shall constitute a quorum at any meeting. There shall be no proxy voting.
Okay.
So members are members. The problem with trying to say, I mean, I don't know that anyone cares, but the problem is, if you have a 7-member commission and 3 of them are absent or not appointed or the positions aren't filled, then an applicant has to go 4 for 4 with the remaining. And there's no provision that I'm familiar with that requires a unanimous vote. So that's why you run into this conflict, and that's why it's a more important issue than it might first appear to be.
I think maybe just a simple additional language, if there are vacancies, then, you know, we'll revert to the LUDC, or just something that externalizes it and makes it less implicit, if you will, for the public's
Yeah.
understanding.
maybe a language, something like a quorum for the Planning and Zoning Commission shall be more than 50% of the appointed members?
Yes.
Would that work? Would that pass muster with you, Brian?
No.
Nope, okay.
So why don't we use the same language as the LUDC? Then we're in harmony.
I just want something where the public can go back and see
Yeah,
that we're making a decision. And if this is quorum here, that's fine with me, but,
yes.
and if that's the, you know, what states somewhere else, they know where it's at and they can, and they can read it, but just looking at the bylaw, it doesn't state that.
Okay.
That's the next point.
All right, let's move on to the item, I think that's gonna be the most discussion here. Mr. Chairman Lukes, excuse me, Vice Chairman Lukes, is that what you are?
No, I'm not, neither. No, actually, it might be just a short discussion. I think we can just simplify it and just put term limits on the position of chair and vice chair. Because my intent was all along was so there's change and other members of this body have a chance to lead meetings and assist and to get the experience. So, and I think term limits would satisfy that. And as far as electing, just leave it up to the wisdom of the commission itself.
And in regards to this particular annual voting, do you wanna proceed forward as it is this year, or do you wanna try to?
Don't just proceed as for this year, just proceed as it's been already voted upon and just place, and I would suggest 2-year limits on the positions of chair and vice chair. And if anybody has other ideas, if there are any criteria to be considered when nominating for those positions, I'm open to that too, but my main desire was to bring some inclusivity of others.
Commissioner Garcia, do you have any comments?
Well, I don't have an issue with that. I mean, there are certain members that don't want to become the chairman or vice chairman. They want to be involved, and for whatever the reason, maybe they don't have the expertise, or their time constraints doesn't allow them to be at that focal point. And so,
And they can decline. Then when nominated, they can decline and we move on.
yeah, I don't have a big issue either way. I think where there was some, and unfortunately, you know, we don't have two positions filled, and that, I think that caused some of the concerns, or why this has been brought up. But when someone is leaving office,
Oh,
and
was an
that
issue
makes
with me,
makes it
right.
a little more difficult to swallow, because they're leaving, that was their last meeting, and they're making motions. Now, saying that, there was only 3 members, and so what do you do? So, you know, I was absent, I was aware of the meeting and what was on the agenda, so, I don't have any issue with the process. It's just that, I think that caused some of the heartburn a little bit, was a member leaving and voting and making it basically the majority kind of thing.
Yeah, I think it was a poor judgment to do that, because.
It should have been
let's sup-
tabled.
Yeah, let's suppose it was a different issue, that a leaving member would make a motion on, that would have settled the commission with an obligation, but not the leaving member. He's already gone, and, okay, guys, you live with it from here on. So
I think
I had a problem with that as well.
I think it's a good point. I don't necessarily think it needs to be codified. I think it's a lesson learned that we need to be, you know.
And call somebody on
honorable
it if they don't have enough judgment themselves. Call them on it and say, look, you really shouldn't make this motion, you're lame duck.
And again, I don't think there was any intent. Honestly, I don't think that at all. But for future, going forward, we should be aware of that, and when we're making any type of decision like that. But as for vice chair and chair, annually, it should be done. Term limits, I mean, maybe if somebody's been sitting on it for 2 years, maybe at least give an opportunity for others that maybe might be interested in sitting in that level. But again, I don't have, that's my input in that.
So I would make that motion to include term limits,
Okay.
2-year term
Well,
limits.
I'm gonna ask staff if they have any comments about, Mr. Pereira, do you have any comments on this?
Chairman Lee and Commissioner Lukes and Commissioner Garcia, the points Commissioner Lukes brings up are very good ones. I think it is in theory to at least give each commissioner the opportunity to be chairman and vice chairman. I think it's something worth looking into. And also under section 7, where you see that in the bylaws, it just says the officers shall consist of a chairman and vice chairman elected by the commission at the first annual meeting for a term of 1 year. There is no provisions in this section to allow for another election if the chairman or the vice chairman resigns. So I would recommend adding something in that section, some kind of language that allows the commission to hold another election as needed if, you know, for some reason the chairman or vice chairman resigns, or, you know, the commission no longer wants to be chairman or vice chairman.
I don't know, I'm gonna
I don't
ask
know.
Mr. James real
If
quick,
that-
but my understanding is that would probably be covered by the LUDC as well. Some kind of implicit understanding that if there's a resignation, that you could have another election for officers.
Actually, the only thing that's covered in the code is if there's a vacancy on the commission generally, then the commission has to notify the town manager, and the vacancy shall be filled by appointment of the mayor with consent of the town council for the remainder of the unexpired terms. There is reference in the code to term limits for members of the commission generally. Can be reappointed for no more than 3 consecutive 2-year terms. So to the extent that the code discusses term limits if you want to term limit the chair and the vice chair, it might be a good idea to suggest to council that they change the code. The only caveat I would have is, well, you guys are ready, willing, and able to serve. We've had a little problem finding others similarly situated, and to the extent that it puts pressure on a commissioner to serve as a chairperson or a vice chair, which I think is a lot more time-consuming, as Commissioner Garcia has pointed out, would be unfortunate if somehow your revolving chair had a chilling effect on people's willingness to be serving as a commissioner generally.
Yeah, we certainly don't want to restrict it, and so I know I've served on the school board, in fact, 2 terms, which was 8 years, and it was just an understanding how that process, vice chair would move up, and we would elect a vice chair, vice chair to fit there, and continue going that. Now, if there's some issues with the commission or with a board or something, they could manipulate who they want to select there and put on there, but it's a difficult situation. My bigger issue was, and it's been a challenge that we don't have those positions filled. And
What's the status anyway?
Mr. Chairman, Commissioner Lukes, it's my understanding that, I defer to my boss, Oscar Rodriguez, on that because it's the mayor's in the process of reviewing applications, so I'm not exactly sure what the status is at this point.
That is the status, the mayor's reviewing. I can't give you more than that. I have discussed it with him. He's aware of the people who've applied. He's got all that information. And that's where it stands. He makes that decision at the end.
it just makes it challenging for, the people that are on the board right now. We have other jobs, and, I have to be in Albuquerque at 6:30 tomorrow morning, so I'm gonna be getting up early, but I came to this because I knew we needed a quorum, but, so the sooner, just related to the mayor, the sooner the better, because that makes it a challenging situation for the ones that are on the board right now, on the commission.
Mr. Chairman, the other thing that the commission could consider, it doesn't have to be 7 members. You could reduce it to 5.
I actually think it should be 7, because it does give a little bit of flexibility to some of the members.
If they can attend, yeah, shorten it makes it tough.
Commissioner Lukes, do you have any suggested language that you want to introduce that could potentially be added to the draft, so maybe we could adopt the bylaws at the next, or at least get it through a preliminary hearing? I don't know if we need to do that.
What do we need to do to add to the bylaws? Do we make a motion, and
Yeah.
if the motion carries, then you go and incorporate it into the bylaws?
Yes, and I guess the only question I would have, Commissioner Lukes, for our town attorney is if the amendment of the bylaws, is that a public hearing required to do so?
All the code says is that you can make your own rules and bylaws.
Okay, so
That's what I think.
it's not necessary to hold a public hearing in order to amend, in other words, to publish in the newspaper and stuff like that to comply with the Open Meetings Act? Is that something we need to consider when the commission is ready to amend the bylaws?
Well, there's all kinds of stuff in here that says when we're supposed to have a public hearing. The relative to the rules for its own affairs is very simple. It says the commission shall adopt rules for the conduct of its affairs. No reference to a public hearing, although there are many other references to public hearings throughout. That would suggest to me that a public hearing is not necessary.
Oh, okay, okay. Thank you, Mr. Town Attorney. Okay, so,
Commissioner Lukes, do you have suggested language you want to put in?
Make a motion to limit the position of chair and vice chair to 2 consecutive years.
okay, and Commissioner
second?
Lukes?
We can have a discussion.
Or
Okay, I'll have a second for discussion.
Okay,
Okay.
discussion.
I'll second that. Again, on our agenda, it reflects that it's to review the proposed update bylaws. I don't think we should be acting on it at this time. I mean, what I think you were asking is to give some language that they could amend and put it in our next commission meeting, so we can, as a commission, vote on it. Voting on it now is, I think is premature
I think what might be appropriate is Commissioner Lukes gives some suggested language. I think we all have the same idea of what we're trying to do here. And then we would ask Mr. Pereira to put in a final draft bylaw, if you will, that we could by motion adopt at the next meeting.
Okay, exactly.
You guys, are you comfortable with that?
Sure. Yeah, and including the language regarding quorum.
Okay, and Commissioner Lukes, if I may, and you want that language added to section 7 of the bylaws, is that correct, where it talks about the officers?
Yeah, I think that would be the appropriate
Okay,
place for it.
all right.
May I ask a question?
Sure, just make it brief. Come up to the podium. You swear to tell the truth?
Yes, I do. Name's Jeff Northrup. And my question is, will this go into effect so that that'll prohibit the current chair and vice chair from being reelected next January? Or will next January be considered the first term if, let's say, Mr. Patterson is elected chairman again?
Mr. Patterson has served, I think, three terms as chair, so his tenure would be over.
Okay.
Chair Lee has another year, and he can be moved up to the chair or whatever,
Okay.
but he's just been elected. Am I
Okay,
correct?
so it'll go into effect, I don't know what you call it, ex post facto or whatever, that
Yeah, the
Ms. Patterson's through.
Yeah, the effect should be immediate.
I think the answer is it'll apply starting this year.
That's what I was gonna say.
Yes. Okay, so we're gonna move on? Are we okay, Mr. Pereira?
Yes, and is there any other language you would like to add? Is that good enough, Commissioner Lukes? Commissioner Garcia, was there anything else that you would like to add?
Mission accomplished, almost.
Just on the quorum section, if we're, just to make sure that it's clarified that the code trumps what we have here as bylaws. Again, I still have, somebody just looking at this, 4 members is a quorum. Well, we don't have 4 members. Right now, we're saying majority of the acting commission.
Okay,
And I don't know what kind of language, I don't have any recommendation, I just want it to
Okay.
be very transparent, what translates as a quorum.
okay, yeah, thank you, Commissioner Garcia, that's a good point. What I'll do is, I'll review the LUDC, and then I'll work with Brian, our town attorney, and then we'll come up with some language for you guys to consider for the next meeting for that, because you brought up some very valid points there in that section. And so I'll do research on that before the next meeting and bring that to you for the regularly scheduled meeting in June.
Okay, let's move on. Discussion of the proposed changes to the sign ordinance. Mr. Pereira?
Okay, thank you, Mr. Chairman. It's my understanding from Mr. James that these proposed changes will be brought to the town council now in May. Is that correct, sir?
Yeah, I missed my date for the second meeting in April badly, so we have now put this on the agenda for the May 28th meeting.
And
Okay.
I guess the question I have is, at that meeting, is that the date that it would be adopted?
Yes.
Okay, and that's important to understand, Vice Chairman Lee and Commissioners, is because this is the opportunity that you will have to give feedback to Mr. James before this ordinance is approved. So in other words, next month, this won't be brought back to you because this was already, this is already going to be approved by the town council on the 28th. So it's important that you give your feedback now to us before.
I'm gonna just make a comment.
Sure.
Can we, if you can recall, Mr. Pereira, can you take us through the history of how this ordinance has come before the Planning and Zoning Commission? Because
Okay.
my understanding, it was drafted, and then it was torn apart, and then there were different employees of the town that were working on it, and then they resigned or left, and then there were new
Yes.
people working on it. And then,
That's correct.
so can you go through that a little bit?
Yes, what happened is that our previous planning and zoning director, Mr. William Morris, He took the lead in our department on doing some revisions to this sign code. And there was quite a few issues with some of the revisions he had proposed. And so what we did was we had formed a little committee with our then acting planning director, Matt Foster, and Rachel Romero, myself, and Mr. Foster went through the sign code one more time, and we proposed changes to the sign code. And then that's when, of course, we've been getting feedback from Mr. James, our town attorney, through this whole process on trying to figure out how to best craft this sign code that works for everybody. And so after Mr. Foster resigned, this sign code was then turned over to Mr. James to review and consider, because prior to this sign code being turned over to Mr. James, the town council had reviewed a draft version of this, which is a earlier draft than what you have before you now. And they were not happy with the proposed revision, so they turned it back over to staff. And then that's where Mr. James became actively involved in actually drafting this latest version of the code, working with Rachel Romero and myself to try to figure out the best way to, come up with a good version of this.
I have another comment, question. Sure. The situation that we were in, we were led down a path that it seemed that we were going to be given some kind of responsibility of adding input into this particular code before it was adopted. And it's on the agenda tonight as a discussion item.
Yes.
And it's going to be discussed by the town council.
Yes.
Regardless of our comments, because we're not making a recommendation as to its adoption. We're not making any recommendation as to changes, because it's not on our agenda to do so. So I'm wondering, it seems like it's 180 degrees from where we were before in what we consider our responsibility on the sign code. Is it the town council's or the town staff's direction that whatever comments made by the Planning and Zoning Commission are not necessarily necessary to the adoption by the town?
Well, that is, I guess part of the confusion is this. Right now, the sign code is not part of the development code, the land use development code. Changes to the land use development code have a process you guys are more than familiar with. This falls outside of that process. One of the changes that we're suggesting strongly is that we put the sign code into the land use development code so that future amendments would go through your normal process. In an effort to try to broaden the vetting of this, at Oscar's direction, we brought this to the Planning and Zoning Commission for purposes of using this as a forum to sort of vet this, get your input. Even though it's not legally required, obviously it's something you have an interest in. We thought that perhaps this would generate more public comment than it actually has. So we're outside of the normal review process of planning and zoning, and we tried to do that to be more inclusive as opposed to exclusive. It sounds as though we've offended the Planning and Zoning Commission by not respecting what you're saying, because we're taking this back to council to vote on it. Through no fault of the Planning and Zoning Commission, there's been an upheaval in the planning department. I have to get this done. And which is not to say that any comments that you guys have made in the past haven't been considered. Any comments you want to make tonight will be considered. We'll certainly incorporate as many as possible of them for the document that's being presented to council. I would like to say additionally that some of the comments we've heard tonight about the fluff or whatever it was called at the beginning of this ordinance was actually drafted over a period of nearly 3 years in a different jurisdiction using some extremely experienced First Amendment lawyers and professors in the state of Michigan. Some of this fluff is extremely valuable when it comes to trying to enforce provisions in the sign code in front of a court by establishing a rationale for the code language itself. The other huge change that occurred since the beginning of this process is, and I've told you this before, Mr. Morris was advised by the Highway Department that the town would be the recipient of some sort of an agreement to allow for some sort of enforcement of the sign, of local sign ordinances in the state highway right-of-way. It turns out that the State Department of Transportation is not interested in assigning to us any enforcement rights, or any rights at all for that matter, in the right-of-way. Therefore, this defaults back to the New Mexico Administrative Code, which has extensive rules relative to use of rights-of-way. So the original draft of this, which you may recall seeing with safety zones and those sorts of things in it, was just not usable because we just don't have any authority to enforce. So the thing had to be, the Morris version, if you will, had to be gutted because it was primarily built around that. And so this looks substantially different. Now, in an effort to recognize the direction from council that free speech is obviously a valuable commodity, we have removed any picketing provisions whatsoever, and we've removed any election sign provisions whatsoever. The political speech is not covered, is not restricted in any way by this ordinance. It just isn't. So in that terms of the town attempting to regulate picketing, handheld protest signs, any of those things that have been heard about at this meeting or heard at earlier meetings during public comment simply do not exist in this ordinance. They've been removed. And they were removed at the direction of the town council in discussion with them about this ordinance. The rest of it, the remaining controversial issues are whether temporary signage should be counted against the maximum signage allowed. And another bigger issue, a big issue, is the continued existence, legal existence of these signs that are single poles with fabric attached to them. Beyond that, I don't think, and with the cleaning up of the language about and removing language trying to prohibit picketing signs, beyond that, this is not substantially different than the ordinances that exist right now. So that said, the third remaining issue is amortization and nonconforming uses, which was suggested by my office and approved by the Planning and Zoning Department staff. Got no legs whatsoever with the town council, and I don't expect at the end of the day there will be an amortization provision. There may be an amortization provision that is sort of a compromise on these single pole fabric signs to allow people to continue to use them for whatever their useful life might be, 6 months, 9 months, a year. But those are the essential changes. So the sea change that you were promised relative to signage is not here. And that's primarily because of the refusal of the Highway Department to allow any alterations to their existing rules in the right-of-way, which for purposes of aesthetics and safety was the biggest concern, and we thought we were going to address it in one way, and we're not able to do that.
Can I speak for a second?
Not yet, Mr. Commissioners, any comments?
Well, I feel the same way what you have expressed, that, but I didn't say anything because I thought it was my own fault that I just missed something, opportunity for some feedback. I didn't expect this to go to the council for final vote without our having a little more time on this. So that's where I am.
And just to follow up, I agree with everything that's been said, and I guess I was confused on what the process was going to be, just I think as the rest of the commission was. So saying that, and understanding what our role is and so forth, I don't want to get into a debate or into a further discussion on this. I think as commissioners that are on, we can probably share, like any other citizens, our opinion or input to the town as individuals. But as a commission, I can't see us making any kind of uniform decision or input into the code when the council is going to make a decision in a few weeks.
Well, we can always go back and ask for amendment if we as a commission identify some issues with the ordinance.
Well, as they mentioned, that they're looking at maybe changing that role where the commission can look at this piece of it. And you're right, we can, down the road, if there are areas of need, of discussion, it can always be reviewed and submitted to the town to see if they accept what we see. But at this point, at this juncture, I don't see any more discussion should take place. That's my opinion.
Yeah, I agree.
Well, I think, to the contrary of the commission, I think that we should have a little bit of a discussion, regardless of whether we can have any effect as a governmental body on the town council's decision. There are people here. Is there anybody in the audience that would like to speak on this matter?
Well, I'd like to speak briefly. Mr. James.
State your name, please.
My name is Jeff Northrup, and Mr. James indicated that great minds in the world of free speech were happy with the introduction to this code, and they may or may not have been, but of course the introduction is not, in fact, the code itself. I think the town has clearly within this code ceded this definition of the right-of-way to whatever the highway right-of-way is. And the highway right-of-way is ill-defined, as far as I know. Pavel says that you can go and look at some sort of things that at the county and the business can determine where their right-of-way is, and I'll assume that he's right. But on the other hand, looking at that old right-of-way map from 1977, and I don't think anyone has an updated map from them, going all the way from the Kachina Lodge south to the edge of town on Highway 64, then 68. It seems as though it's probably the right-of-way is probably 200 feet wide, 100 feet on either side of the median line, I would suggest. And looking at that, with even when the roadway is 5 lanes wide, I think that's about 80 feet or a little less, maybe 75 feet. And so that's half of that's 37 feet, which would mean there was 63 feet past the curb that would be considered the highway right-of-way, and signage not allowed. 63 feet. That's 20 long steps between the curb and the end of the highway right-of-way. And then it speaks of things that that I don't necessarily understand, such as ditches, culverts, ramp turnouts, maintenance easements, and I don't know what all those things mean, and how have those things changed since whatever the county has, possibly like you were suggesting, Pavel, related to a business could go in and see what their where the right-of-way extends on their property, but maybe that's changed since in the 30 years since that business last looked or last located there. Maybe the maintenance easements have changed. I don't know what it all means, and I don't think anybody else knows what it all means. And until businesses can find out where the line is that stops them from putting signs any closer to the road, I think we need to hold up this whole thing. And I don't think the town council should be voting on it. I think you guys need to look into the various definitions, and maybe at your next meeting, spend 2 or 3 hours going through this word for word, as they said in the one part. And with all due respect to the town council, I don't think any of them are going to take time to read this with any detail, but where I was saying if 10 or 12 businesses are in one place and they can have a total of 100 square feet of signage, that's ridiculous. It's, a sign this big. How can the whole thing doesn't make sense. There's holes in it like that that need to be fixed. and there's no way you guys can act on it tonight. It's too long a document. You need time to look at it. And I think this document only became available 3 or 4 days ago, and everybody's busy. Pavel, you're out of town. Justin, I know you were. Raton, Albuquerque, all over the place. Dennis, I don't know what you were up to, but I don't think you guys had enough time to really review this thing. And you need time to review it. The businesses need time to look at it. And I would say the town council shouldn't even consider voting on this until sometime in July, giving everyone, having some public hearings on this, giving the public right to look at it, giving people interested in free speech a right to look at it, and giving businesses a right to look at it. It's a hugely important thing. Businesses are suffering in this town, and this ordinance does nothing to relieve that suffering. In fact, to me, it makes it much worse, or the potential to make it much worse. And this is just my opinion. You let other people read these things, and we'll see all kinds of good ideas that might come out. I'm just one person, and I'll be amazed by the comments that will come from others for the insights they'll have into this draft and ideas that they'll have for better regulations. And just leave it up to Mr. James and his expert on free speech. I don't think is right, because again, the town council is in a rush to judgment. As far as I can see, I won't be able to set up my signs where I've been setting them up before. Mr. James seemed to indicate that I could pretty much continue to do what I have been doing, but I seriously doubt that that's the case, especially when I don't have any idea where the highway right-of-way is. I'll be picketing behind trees and behind buildings.
Mr. Northrop, Mr. James, I think maybe a simple explanation here might be very useful. My understanding is that the New Mexico State Highway Department, they have jurisdiction over the state highway right-of-way, and the town has to comply with whatever they decide to do. So it's not even within the town's purview to control that area. Is that correct?
Yeah, I thought that's what I said, but if I didn't, what you said is absolutely correct.
So it's not even, the town could draft all the ordinances in the world regarding the protection of free speech on the highway right-of-way, and it would do nothing because the state highway right-of-way rules trump yours.
That's correct, and I can tell you that I've done an incredible amount of research regarding right-of-ways in the past 3 weeks for unrelated reasons, and I would refer Mr. Northrop or anyone else who's interested is this stuff is not secret. It's Title 18, Chapter 20, Part 5 of the New Mexico Administrative Code, and this stuff has been law. Most of this was passed in 2001.
So what you're saying, Mr. James, is I can go out to this 1825 and find out exactly what the right-of-way is in front of Wendy's?
Okay, time out.
Or
The question, again, Mr. Northrop, we understand your concerns. I think that we all have the same concerns as you do, not having the ability to talk about some of the details of how we might be able to change it. I think that's a discussion that unfortunately you're going to have with the town council, because we can't make any recommendations specifically without any type of motion and action by this board. That being said, I think the general comments are that the state highway right-of-way is the state highway right-of-way, and it has, the state highway department has control over that. Now, I think the other comment that addresses some of your issues specifically is that the town also does not have the ability to enforce anything on the state highway right-of-way. That is of the state's purview on how they enforce their own code. So where it is no jurisdiction for them, it is no jurisdiction for them.
Well, what I'm suggesting, Justin, is that the town pass its own ordinance as they, regardless of what the state has to say, pass it what they think is best for the businessmen and the people of Taos, pass our own ordinance, do our own definitions, and then if the state chooses to impose their rule, let the town challenge them and say, wait a minute, this is our town, this is how we want to operate it, and make the state show that their rules are necessary for public safety, health, and welfare, and don't unfairly encroach on the rights of the citizens of Taos, businessmen of Taos, to define what they think is best for their own town. Again, if my calculations are correct, it's possible that certain businesses may not be able to have their signs within 60 or 70 feet of the curb. And of course, knowing the town of Taos as I do, It could be that in the case of businesses that encroach on that state right away, they may not enforce it, but in the case of my picketing, it will be enforced. And we'll be back to where I've been for many, many years with the town as far as selective enforcement of whatever laws they choose to enforce or make up.
I think.
Sure.
Go ahead.
And some of what I'm gonna say might be a little speculative. Every business owner can find out where their right-of-ways are. Every business owner can find out where their easements are, utility maintenance easements, i.e. Kit Carson easement, i.e. gas company easement and whatnot. And I would dare to bet that some right-of-ways in the area that you mentioned, from south of Kachina, I don't even know how big, if there are any right-of-ways, because those streets have evolved with not much room, so unless the state went through some condemnation to take some private property for the purpose of a right-of-way, those right-of-ways might be very, very minimal. And it's up to each business owner to find out where the right-of-way lies, and it's a really simple process. Is go into county records, look at surveys, and it's clearly delineated with lines and notes. There's an easement for Kit Carson, there's easement for gas company, and a broken line for highway department right-of-way. So some of your concerns may actually prove to be not necessary.
Okay, well, I hope that's the case, but I also don't quite understand why a gas line easement would have anything to do with signage. If the gas line's, whatever, 6 feet underground, what difference does that make? You know, what's wrong with putting signs above it?
I didn't see any language or heard any language about prohibition signage in easements. I think that you can actually build things in easements. We're talking about right-of-ways where the town has absolutely no jurisdiction.
Well,
And the state highway department will prohibit you from putting signs there, because I know.
Well, that, in this,
Signs, though.
in this right-of-way definition that's given on page 18 of the draft,
It's right-of-way, I thought you were talking about easements. You can put
it has the word maintenance easements in it, where I'm not sure what that means, but it says maintenance
All right.
easements.
We're getting a little off topic here.
Yeah.
I think we should sum it up unless anybody else has some additional comments. I think
Commissioner Lee, Vice Chairman Lee, I just have one comment on the easements. In our department, before we issue any sign permits to any property owners, we make sure that the business owner proves to us that they're not going to be placing their signs on any easements, like gas lines, water lines, sewer lines. And if they are going to be doing that, then what we do is we make them get a letter from the owner of that easement giving them approval to do that. So it's not an automatic thing for anybody who wants to put up a sign that they can just place it in an easement without getting permission and without us verifying, the fact that they did do that before we issue them a sign permit. So just for the record, I just want that mentioned that, we don't allow people automatically to place signs in easements without permission from the owner of that easement. So
I understand. Thank you.
All right, one more statement, and I'll leave you
Sure.
alone, if you don't mind. I would suggest that, if nothing else, you ask the town council to put off voting on this at their May meeting until this can be discussed in public forums, until the sign code can be discussed in public forum.
I think that we could make a suggestion to Mr. Pereira to make that comment heard by the town council, but I don't think we can take any action because we don't have an action item to act upon, and unfortunately, that's just the way it is.
Okay, so what is it you're asking Mr. Perea to relay to the town council?
In the commission can correct me if I'm wrong, but I think it would be our suggestion that the town council delay making any adoption of this particular sign code to allow the planning and zoning to actually review it. However, I will comment, that being said, Mr. Perea, that Mr. James made a point earlier that this is outside of our purview anyway at this point because it hasn't been adopted as part of the land use development code for us to review. So it would, in a legal sense, it would be impossible for us to review anyway at this point.
Mr. Chair, Mr. Rosary, you mentioned that, business people, you were concerned about business people. I kind of it's disappointing actually that the business people did not get involved more in the process. It's been advertised, it's been written about in the paper that this sign ordinance is being considered. And maybe you ought to talk to the Chamber of Commerce and get their interest. This is about them.
I let Brad Malone know that this meeting was going on tonight. I don't see him in the audience, nor do I see that he sent anyone here. You know, as so often happens, I'm in this position to try to help people who are too lazy to help themselves. And I've been there my whole life, and you know, I don't get discouraged. I keep going.
It's disappointing because they'll be affected. The business people will be affected by it, and they don't want to know.
Thank you.
Thank you, Mr. Monroe. Mr. Perea, let's move on to discuss commissioner training briefly.
Okay, thank you, Vice Chairman Lee. I just, as I mentioned at the beginning of this meeting, I just arrived back from the first day of our, my League of Zoning Officials Conference, and what I have here is a Land Use Officials Handbook, and this is the latest version that discusses, you know, topics regarding commissioner training. It talks about commissioner members' code of conduct, coordination with staff and governing bodies, procedures for planning and zoning commissions, et cetera, et cetera. And the latest updates on this are dated from March 2013 of this year. And what I want to do, Mr. Vice Chairman and Commissioners, is I'm going to speak to Mr. Randy Van Vleck at the conference tomorrow and make sure that he gets us all copies of this for the commissioners to review. And I will also be discussing a timetable for when Mr. Van Vleck can come up and do a training with the commission. And I've already spoken to the Historic Preservation Commissioners, and they will be unavailable this month to do any kind of training. So at this point, what I would do is I would just ask you if you can give me a rough time frame as to when you think you would be available to have this training, so that way I can work with Mr. Van Vleck tomorrow to come up with some kind of schedule to get you guys this type of training.
Just the one question, comment back at you.
Okay.
The ideal situation would be to train all the commissioners.
Yes,
Including
absolutely. That's
including
what,
the new two that are not appointed yet.
exactly. That was
So-
my hope.
So do we want to wait until we have an appointment before we make a decision as to when we're doing a training?
Well,
Vice
this month
Chairman.
is shot anyway, so let's shoot for June, and hopefully by then they'll be appointed.
Okay.
If you're comfortable, I mean, if you just want to put a date out there, sure. Put it at the end of June sometime.
Okay. Okay, Mr. Vice Chairman, Commissioners, I'll go ahead and talk to Mr. Van Vleck and see. And is there any particular day that works for you guys as a commission, like a Friday or a Monday?
Mondays work really, but if you're gonna do it in June,
Okay.
the best thing for me anyway, I can't speak for the rest of the commission, but the sooner you have some dates, the sooner I can see what my schedule looks like
Okay.
and put you on, put this training on there. So,
Okay.
you know, if you're asking a week or 10 days beforehand, it's gonna be challenging to.
Yeah, no, I
pick a
understand.
date, So,
Okay, so actually what I'll do, Mr. Vice Chairman and Commissioners, is I'll talk to Mr. Van Vleck tomorrow, and I'll let him know that, you know, the commission is interested in getting this training in June. And then I'll check with his schedule, and then once I get his schedule, I will email you guys, and ask, you know, if these, you know, dates and times that he has available in June would work for you guys.
Yeah, I think 3 suggested dates, and then we'll just try
Okay.
to see the
Okay.
majority of people that can make it. My preference would actually be during like a lunch hour, during the day, rather than at night, but I don't know if that's available.
Okay. Yeah, and I think this is a critical issue, Mr. Vice Chairman and Commissioners, because both commissions haven't had this formal training for a couple of years already. So I think it's critical that all the commissioners all sit down at the table at once and, you know, be allowed to get this type of handbook that's very useful and very informative, and you know, it's very worthy. So at this point, I'll go ahead and talk to Mr. Van Vleck and then get back with you through email as to what dates work for him and see if that works for you. Okay.
Any matters from commissioners?
Move to adjourn.
I'll second it.
So moved. Everybody in favor?
Okay. Thank you, gentlemen. I appreciate it.